On November 24, 2023, the federal court released a decision which discussed whether membership in the Palestinian Authority makes one inadmissible to Canada. The case is Mohammed Bashir Shala, the Canada Minister of Citizenship and Immigration. The neutral citation is 2023 FC 1561. In this case, and as I'll just scroll down through the judgment, we can see that the applicant, Mohammed Bashir Shala, seeks judicial review of an immigration division decision finding that he is inadmissible pursuant to paragraphs 31B, C, and F of the Immigration and Refugee Protection Act for being a member of an organization that has engaged in terrorism. The Immigration and Refugee Protection Act, which you can see here, prescribes at section 34(1) that a permanent resident or a foreign national is inadmissible on security grounds for B, engaging in or instigating the subversion by force of any government, C, engaging in terrorism, E, engaging in acts of violence that would or might endanger the lives or safety of persons in Canada, or F, having been a member of an organization that there are grounds to believe engages, has engaged, or will engage in any of the acts referred to here. So, going back to the case, the Immigration Division concluded that there were reasonable grounds to believe that the applicant's employment with the Palestinian Authority was equivalent to membership in the Palestinian Liberation Organization, which the Immigration Division found to be an organization engaged in terrorism. So, what this case gets into, in addition to the specific issue of whether membership in the Palestinian Authority makes one inadmissible to Canada, is what the case law is regarding entities that are affiliated or where one organization can substitute possibly for another. For those who don't know, according to Wikipedia, the Palestinian National Authority or the Palestinian Authority is officially the state of Palestine, and according to Wikipedia, is a Fatah-controlled government body that exercises partial control over the West Bank and after the Oslo Accord. I should note that Wikipedia says that it is a Fatah-controlled government body, but from what I understand, that's contested. The Palestinian Liberation Organization, meanwhile, according to Wikipedia, is a Palestinian nationalist coalition that is internationally recognized as the official representative of the Palestinian people. So, at first glance, without knowing anything more, the two organizations seem like they're related, but obviously, the first few sentences of a Wikipedia page is not going to be determinative of this in court. Back to the case, the applicant himself, Mr. Shala, is a 62-year-old Palestinian national from Gaza. From 1997 until 2007, he was employed by the Palestinian Authority in Gaza as a secretary to the general in charge of the logistics branch of the Palestinian Authority. Skipping down, and as has been noted in the news lately, in 2007, Hamas, a terrorist organization, took control of Gaza. And in 2008, Mr. Shala retired from the Palestinian Authority and makes a refugee claim, makes his way to Canada. The Canada Border Services Agency reviews his application for refugee protection and determines that he is inadmissible to Canada for paragraph 34(1)(f) of the Immigration and Refugee Protection Act, which, as I mentioned before, is that someone is inadmissible to Canada if they are a member of an organization that has engaged in subversion, terrorism, acts of violence, etc. The Immigration Division found that he was inadmissible to Canada, as the Canada Border Services Agency said, and issued a deportation order against him. A deportation order is a lifetime ban on entering Canada. The crux of their decision and what was being challenged in federal court was that Mr. Shala was a member of an organization that there are reasonable grounds to believe has engaged in or instigated subversion by force of a government and engaged in terrorism. The Immigration Division found that there were reasonable grounds to believe that one, the Palestinian Authority is an internal organ of the Palestinian Liberation Organization. Two, that the Palestinian Liberation Organization is an organization engaged in or instigated the subversion of a government. And three, that the Palestinian Liberation Organization is an organization that engages in terrorism, and that Mr. Shala, by virtue of being a member in the Palestinian Authority, is a member of the Palestinian Liberation Organization. Now, one thing I'll note about this is that none of these organizations are listed as terrorist entities on the Public Safety Canada website. And for purposes of being inadmissible to Canada, it is not necessary to be listed on this website as long as the visa officer or the tribunal believes that there are reasonable grounds to believe that an organization has engaged in anything that would be encompassed of terrorism, being a danger to the security of Canada, etc. So while there are some organizations on this list pertaining to Palestinian militant groups like the Palestinian Islamic Jihad and the Palestinian Liberation Front, the Palestinian Liberation Organization, the Palestinian Authority are not listed as terrorist organizations by the Canadian government. There's Hamas. Um, so going back to then obviously membership in any of these organizations, you don't really, like, the federal court is going to find that it's reasonable for a visa officer to determine that someone is inadmissible to Canada for being a member in these organizations. It's not as automatic with entities like Palestinian Liberation Organization or the Palestinian Authority that are not on this list. So scrolling down, the Immigration Division, this is just some of the history of the Palestinian Liberation Organization and plots that it was involved in to overthrow the Jordanian government, and that the Palestinian Liberation Organization launched attacks on Israel and Israeli soldiers starting in the late 1960s and 1975. And their federal court and the Immigration Division went into quite a lot of detail about why it was satisfied that the Palestinian Liberation Organization is an organization that membership in would result in someone being inadmissible to Canada. The crux of this decision, though, is was it reasonable for the Immigration Division to find that membership in the Palestinian Authority equals membership in the Palestinian Liberation Organization? The federal court, Madam Justice MacDonald, went through the law on how this assessment is done. The paragraph 27 of the decision writes that in applying the reasonable grounds to believe standard for inadmissibility under the IRPA, their decision must have an objective basis for the belief that is based on compelling and credible information. It then cites, Madam Justice MacDonald then cites the Federal Court of Appeal decision in Canagendren v. Canada Citizenship and Immigration. This is a case that I've cited quite a lot in my judicial review practice, as well as in procedural fairness letters involving inadmissibility for security concerns due to membership in this or that group. And it's quite an important case for anyone who works in this area or is representing someone in this area or is being accused of being a member of an organization that may be an affiliate or de facto another organization. And what the Federal Court of Appeal found in Canagendren is that, quote, great caution must be exercised when finding membership in one organization to be a proxy in another. Particularly in the context of nationalist or liberation movements, the mere sharing of goals and coordination of political activities may not justify this type of analysis. And the Madam Justice MacDonald also noted Bigger Mamana v. Canada, Citizenship and Immigration, where Justice Diner found that there must be evidence that is sufficiently thorough and convincing to link the two organizations. And in the rest of the decision, Madam Justice MacDonald notes evidence to the contrary of the Palestinian Authority being a proxy or de facto the same as the Palestinian Liberation Organization. And she noted that there's a lot of documents in the National Documentation Package which seems to suggest the otherwise. The National Documentation Package is on the Immigration Refugee Board of Canada website, and it contains country guides, essentially, or documents that the Immigration and Refugee Board is viewed as credible that can be used in refugee claims. And what is nice about documents on this website is that they are automatically just viewed as being credible and you don't have to vet them essentially. So here, if I click it for the Palestinian Authority and look at the most recent package, um, you can see that there are a lot of documents that people can rely on all sorts of topics regarding a country. So, Madam Justice MacDonald essentially ruled that there's insufficient, or that not that there's insufficient evidence that the two are linked, but that the Immigration Division need to consider all of the contrary evidence, and that the Immigration Division needs to compare the structure, organization, and roles of the two organizations, and that it's not just a question of whether they have the same leader. And there are some other cases involving Palestinian organizations that the court notes that do show just how other judgments involving the Palestinian Liberation Organization, as well as Fatah. And so it's worth noting just that in the Antier decision, it was held that membership in Fatah does render someone inadmissible to Canada, and that if someone says that they are a member of both the Palestinian Liberation Army and the Palestinian Liberation Organization, then someone will be inadmissible to Canada. However, in this case, um, the question of the Palestinian Authority and whether membership in it renders someone inadmissible to Canada is still left open, really, at the end of the decision. And it will be for either a redetermination or a future case to definitively decide whether membership in the Palestinian Authority renders someone inadmissible to Canada. The key takeaway from this case, in addition to that factual context, is again this federal court of appeal decision in Canagendran, which, as I mentioned before, just stresses that great caution must be exercised by visa officers when they are trying to use membership in one organization to essentially be de facto or proxy membership in another.